Let me ask you something about the car you drive. When did you last think of it as a recording device, not a vehicle? A recording device that happens to transport you from place to place. Because somewhere around the late 1990s, that's what cars quietly became. Not through any announcement, not through anything you agreed to explicitly, just through the gradual addition of technology that generates, stores, and in some cases transmits data about your driving in ways that most owners have never thought about once. Your car's computer records the 5 seconds before and after a collision. It logs your speed, your braking pattern, whether you were wearing a seatbelt. Newer vehicles track this and more: route history, connected phone data, how hard you took that corner, whether the lane departure warning fired. That data exists in your vehicle right now, and the legal questions around who can access it, under what circumstances, and what process is required, those questions have real answers. Answers that most car owners don't know until they're in a situation where knowing them would have mattered enormously. Quick note before we go anywhere with this. The word secretly in this title refers to what drivers don't know about their own vehicles, not to law enforcement doing anything covert. Most of what we're going to cover today is documented technology with documented legal frameworks around it. The secret is that almost nobody reads about it until something happens. This video isn't about police wrongdoing. It's about closing an information gap that exists because technology moved faster than driver awareness. By the end of this, you'll understand your own vehicle better than most people who've owned theirs for a decade. Let's start with the most documented piece: the event data recorder, usually called an EDR, sometimes called a black box. Federal regulations have required EDRs in new passenger vehicles since 2012. Estimates suggest the vast majority of vehicles currently on American roads have one. Most drivers have no idea. An EDR continuously records data about vehicle operation. The specific data captured varies by manufacturer and model, but commonly includes vehicle speed, engine throttle input, brake application, whether seatbelts were buckled, steering wheel position, airbag deployment status, and sometimes additional parameters. The EDR doesn't record everything all the time and then retain it indefinitely. It typically operates on a short rolling window, 5 seconds before and 5 seconds after certain trigger events, usually a crash or a rapid deceleration. That window gets written to more permanent memory. In a crash investigation, a serious collision, a fatality, an incident under legal scrutiny, the data in an EDR can be read using specialized equipment. It can tell investigators quite a bit about what was happening in the vehicle in the moments before impact: speed at the moment of braking, whether the brakes were applied at all, whether a seatbelt was fastened. Who can access this data and how? The Driver Privacy Act of 2015 established federal law around EDR data. The core principle: data stored in a vehicle's EDR belongs to the owner of the vehicle. The important exceptions: law enforcement can access EDR data with a court order, pursuant to a lawfully issued warrant, in connection with a police investigation, if required by a federal or state safety investigation, or if the owner consents. That's a real protection. Courts have addressed EDR data in various contexts, and the warrant requirement has been generally recognized for law enforcement access in the absence of consent or specific legal exceptions. But here's the practical reality. In a serious crash investigation, the scenario where EDR data is most often relevant, the conditions that allow access are frequently present. A crash involving investigation creates the legal context for accessing the data. If you've been involved in a significant accident and are being investigated for anything related to it, the EDR data in your vehicle is potentially accessible to investigators through proper legal process. The data in your car's black box isn't hidden from you. It's yours. But in specific circumstances, it can be yours and still be accessed. Now let's talk about something that most people genuinely haven't thought about. What happens to your phone data when you connect to your car? Bluetooth pairing, USB connections, Apple CarPlay and Android Auto. When you connect your phone to your car's infotainment system, data transfers. Your contacts may sync. Your call history may be logged. Text message threads may be readable through the car's interface. Navigation history may be stored in the vehicle's system. Here's the part that matters. The Supreme Court's Riley versus California ruling, which established that police generally need a warrant to search the contents of your cell phone, addressed phones specifically. The question of data that was transferred from a phone to a vehicle's infotainment system, and whether that data in the vehicle carries the same protection, has been addressed unevenly in different courts. In other words, data that would require a warrant to access on your phone might be accessible through a vehicle search under different legal standards once it's transferred to your car's system. This isn't settled law across the board. It varies by jurisdiction. But it's a real question that has been litigated, and the answers haven't been uniform. The practical implication: when you rent a car, when you sell a car, when you lend a car, connected phone data may remain in that vehicle's system. Factory resetting the infotainment system before transferring a vehicle is something worth knowing about. Location and route history. Many modern vehicles with built-in navigation systems store destination history, frequent destinations, and route data. This is designed for user convenience. Your car remembers where you like to go, so it can offer those destinations quickly. It also creates a record of where you've been, how often, and when. Accessing stored navigation data from a vehicle during a lawful search has been addressed in some courts. The analysis generally looks at whether the search of the vehicle extends to electronic data stored in the vehicle's systems, a question that gets more complex as vehicle computing systems become more sophisticated. If you're someone who uses your vehicle's built-in navigation, it's worth understanding that your destination history exists in that system and is potentially accessible in the context of a lawful vehicle search. Connected car services and telematics. Services like OnStar and similar offerings from various manufacturers provide real-time vehicle tracking, remote diagnostics, emergency response, and other features. These services are valuable. They're also generating a continuous stream of location and vehicle data that's stored by the service provider. The legal framework for law enforcement access to this data follows the general framework for third-party data. It requires proper legal process directed at the service provider. Most major providers have published policies about how they handle law enforcement requests, and most require legal process. But as with phone carrier location data, the data exists. The question is always about the process required to access it. License plate readers. These aren't part of your car, but they're part of the data landscape around your driving. Automated license plate recognition systems, ALPRs, are deployed by law enforcement agencies, toll authorities, and increasingly by private companies. They scan license plates, log the plate number, the location, and the timestamp automatically. As you drive past an ALPR, which might be on a police vehicle, a fixed pole, a toll booth, or a privately operated reader, your presence at that location at that time gets logged. The legal framework around ALPR data varies significantly by jurisdiction. Some states have laws limiting retention periods. Others haven't addressed it specifically. The data retention policies of private companies that operate ALPR systems are their own policies, with varying consumer protections. What this means practically: a record of your vehicle's location at specific times and places exists in various databases. That record is created passively, without any action on your part, without any legal process being required for the initial collection. Access to that data for investigative purposes is subject to varying legal frameworks, depending on who holds the data. Practical toolkit: what you can actually do with this information. First, know what your car has. Most vehicle manufacturers publish information about whether their models include EDR systems and what data they record. For connected services, the terms of service describe what data is collected and how it's handled. Second, for sold or transferred vehicles, factory reset the infotainment system. This removes stored contacts, call history, navigation data, and phone pairings that you may not want remaining in a vehicle you no longer own. Third, for rental cars, consider how much personal data you're generating through connection. Whether to use a rental car's built-in navigation versus your phone's navigation is a choice with data implications. Fourth, if you're ever in a situation, an accident, an investigation, any legal proceeding, where vehicle data might be relevant, contact an attorney before discussing anything about your vehicle's technology or consenting to access to it. The question of whether a specific warrant or court order covers specific vehicle data is a legal analysis that attorneys can perform. Scenarios: what if you're in an accident and investigators mention accessing your vehicle's data? This is the most common scenario where EDR data becomes relevant. Cooperate with emergency responders and the safety aspects of the situation. For any investigative access to vehicle data, the same principle applies as always. Speak with an attorney before making decisions about consent to access. What if you're asked during a traffic stop whether your car has connected services? You're not required to answer questions about your vehicle's technical specifications. I'd prefer not to answer questions without speaking to an attorney. Applies here just as elsewhere. What if you sell a car and later realize you didn't clear the infotainment system? Factory reset instructions are available for virtually every vehicle infotainment system through the manufacturer. If you've recently sold a vehicle and haven't done this, it's worth looking into whether your former car's new owner has your contacts and navigation history, not as a legal emergency, but as a practical privacy step. What if you rent a car frequently for work? Consider using your phone's navigation rather than the rental car's built-in system and disconnecting before returning. Many rental car companies now include data policies in their agreements, worth reviewing. What if an attorney or investigator asks for consent to download data from your vehicle's computer? I'd like to speak with an attorney before responding to that request. Downloading vehicle computer data is a technical process that can retrieve more than EDR information depending on the equipment used. An attorney can help you understand exactly what you're being asked to consent to. Here's what I want you to take from this. The modern vehicle is a data-generating system. Most of that data is there by design, for reasons that have nothing to do with law enforcement, safety research, service improvement, user convenience. The data's existence isn't a conspiracy. It's a feature of technology that developed faster than most people's awareness of it. Understanding what your car records, what your connected services store, and what legal process is required to access any of it, that's just being an informed owner of a sophisticated piece of technology. It doesn't require paranoia. It requires the same kind of awareness that any thoughtful person applies to their digital life. Know what your vehicle has. Know the basics of what protections exist. Know that "I'd like to speak with an attorney" applies to any request for access to your vehicle's data, just as it applies to everything else. Now, here's something I want you to think about between now and the next video. We've covered your phone's data, your car's data, your doorbell camera's data. All of it involves technology you own, that you have some relationship with. But there's a category of information that law enforcement has legal access to in ways that don't involve any technology you own at all. Records held by third parties, banks, employers, utility companies, social media platforms. What legal process allows access to those records? What protections exist, and where they're weaker than most people assume? The paper trail that exists around your life, financial, administrative, digital, and the legal landscape around who can access it and when. That's a lot more accessible than most people think, and that's what comes next.